Hello, welcome to Chapter 3 of Cyber Law and Ethics. This PowerPoint is going to start off discussing the concept of free speech, and as most of you probably know, that in the United States we have the right to free speech. But with that said, you have to keep in mind that there are certain limits. So what we see, especially on the internet, and this is, again, it's a cyber class, so we're looking specifically at what is suppressed online by various countries. So in the United States, we do limit access to certain online pornography. In France and Germany, they limit hate speech, and they were severely affected by Adolf Hitler in World War II and the hate speech directed towards the Jewish population, so they are still living under the shadow of the Nazi regime. And then there's China, which suppresses anything negative said against the government. And so consequently, the concept of free speech is very indicative of a misnomer. There's always going to be limits. So, is it wrong? And what is an appropriate free expression for organizations and individuals on the internet? A major complication is the social implications that arise when local governments seek to regulate content based on ideology. So, for example, somebody who is living in North Dakota or in Kansas may be much more conservative towards their social perspective than somebody who lives in Los Angeles or New York City. And as a consequence, their ideologies are going to be significantly different. However, keep in mind that we are all under the umbrella of the USA. Okay, so let's start off with some qualifications of what we're talking about. Child pornography is illegal under all circumstances. However, according to some estimates, the internet has 100,000 sites that offer child pornography. Oftentimes, these are in the deep web or the dark web, as they say, that's not easily accessible by Google or Yahoo. Now, alternatively, we have obscene speech, which is defined by community standards. It is not protected by the First Amendment. So, what does that mean? When is speech obscene? In 1973, in a very famous case called Miller versus California, the Supreme Court of the United States established a three-part test to determine if speech is obscene. The three identifiers, or the three parts of the test, are: number one, it depicts a sexual or excretory act explicitly prohibited by state law. Excretory involves bodily fluids, primarily feces. Number two, it appeals to prurient interests as judged by a reasonable person using community standards. And number three, it has no serious literary, artistic, social, political, or scientific value. Now, you'll probably recognize here that there's some subjectivity being applied, and that's one of the issues in this country, is that my level of what I consider obscene might be different from somebody else's level of what they consider obscene, depending on where we live, what our religions are, what kind of socioeconomics we live within. All of those can contribute to how we perceive something as obscene. Now, children are a special case. In the case Ginsburg versus New York, the court identified certain speech that is not obscene for adults, but is harmful to minors, and a minor is somebody who is 17 or younger. This includes a prurient focus on nudity, sexual conduct, and sadomasochistic abuse. So what we see here is that pornography is oftentimes, and obscene speech is oftentimes protected for adults, but not for children. So your average 15-year-old who is accessing pornography sites is essentially committing a crime every time they do it. However, of course, if you're under 18, you're considered a child and you're not always responsible for your actions. So you get into a lot of different issues in this regard. So let's look at how the United States government has tried to regulate the internet. And these are the three acts that we're going to be looking at. And as you can see, they pretty much are condensed into 4 or 5 years from 96 to 2000, keeping in mind that the internet became commercially available in 1995. So let's start with the Communications Decency Act of 1996. The Communications Decency Act imposed criminal sanctions on anyone who knowingly, 1. Uses a computer service to send obscene or indecent or pornographic material to a person or persons under age 18. Number 2, uses any computer service to display obscene or indecent material or pornography to a person under 18 years of age. And 3, it further criminalized the transmission of materials that were obscene or indecent to persons known to be under 18. And not surprisingly, critical reaction was very loud and very swift. Critics claim that the bill would have a chilling effect on the availability of medical information and prevent people from finding information about sex education. So, for example, let's say that a woman finds a lump in her breast and wants to go online to find information about breast cancer. She types in breast, and of course, 90% of what she's going to get back are going to be sites that are relevant specifically towards people who like breasts and want to look at them. On the other hand, this woman, if she's in a scenario where she can't use the word breast to find the information, what other word is she going to use? The technical term is mammary, but most people don't use that in relation to their bosom. Others claimed it would just violate free speech, and others worried that it would limit the availability of art and literature on the internet. This sculpture on the right-hand side here is a very famous sculpture that has been used in various art books since art books started being presented. And, there are people who would say because she is topless that this is obscene. So, a lot of people are very concerned about what is identified as obscene based on community standards. Somebody who is from New York City and loves art and is very into the culture of everything is not going to see this obscene as much as a incredible art piece, whereas somebody who doesn't appreciate art and doesn't appreciate culture and doesn't appreciate any of that information is more likely to see it as obscene. Additionally, the act could not control sexual content that came from other countries. And that's a very important element, because keep in mind that if a United States pornography company moves to Canada, anyone in the world can pretty much still access their information. You just have to know their web address. The United States' only alternative is to put up a giant firewall that prevents people from accessing any sexual content, which is literally like using a tank to kill a mosquito. So the law was appealed, and the court case became known as the ACLU versus Reno. Janet Reno was the Attorney General at the time. In 1997, the law was struck down by the Supreme Court as violating the First Amendment and the Fifth Amendment, which is relevant to due process. And again, what we saw at this point was the online community really coming together to say cyberspace is a unique concept. It is literally universal, and as such, it's almost impossible to set a law that every other country in the world would have to follow. It's not going to happen. The Supreme Court decision emphasized that the restriction of content for minors actually suppresses the constitutional rights of adults. The court assumed that an internet user has to actively seek out inappropriate material on the internet, whereas inappropriate material on television and radio is more likely accidentally viewed or heard by minors. So what the Supreme Court was saying is, if you want to look at pornography on the internet, you actually have to type it in to the search bar, pornography, naked ladies, naked men, whatever you're wanting to look at. Whereas on television, as you're just flipping through, you're more likely to come across something inappropriate that a child should not be exposed to. So with that act dead in the water, another attempt was made, and this is called the Child Online Protection Act, or COPA, of 1998. This law would make it illegal for people who ran websites to make sexually explicit material available to minors. Webmasters were supposed to collect credit card information before they could let a user into the site. This law also went to the Supreme Court, and the court case became known as Ashcroft versus the ACLU. Ashcroft was the Attorney General who argued to protect this law. So it was argued that it was unconstitutional to require adults to show proper identification in order to practice their right to free speech. And the Supreme Court found that minors could be adequately protected from legal pornography by using filtering software, otherwise known as code, as Lessig had emphasized when we discussed it in chapters 1 and 2. Now, you have to look at it from the perspective of your average adult who wants to look at porn. We all know that the internet is rife with corruption and fraud and scams and identity theft. And who wants to turn over their credit card information to a company that may or may not be legitimate? And again, the idea that somebody runs a company that features pornography doesn't make them necessarily a corrupt person, but people perceive things in their own way, and adults who want some free porn are not really excited about handing over their personal identification, and especially if the pornography is specialized in the sense that people are looking at particular fetishes and things like that. They don't want themselves identified like that. So next we're going to look at the Children's Internet Protection Act of 2000. This law requires that libraries and schools who receive government funding to connect to the internet must use filtering software that blocks obscene images. Librarians objected, and the court case became known as the ALA and Multnomah Public Library et al. Versus the United States of America. The librarians argued that blocking mechanisms will suppress information for adults, and that blocking software is often arbitrary. So again, a topic such as breast cancer would be blocked, and does not block all objectionable content. Additionally, it violates the rights of free speech. The Supreme Court supported the Children's Internet Protection Act as long as adults could ask librarians to override the filter if they sought blocked information. Now, again, what this means is that an adult has to go out of their way if they want to look at pornography in the public library. And of course, the idea that somebody would be looking at pornography in a public place is pretty gross in a word. But again, because we have this right in our country of free speech, it shouldn't be necessarily blocked. So the consequences of this act, because of the law, the burden of protecting children from pornography and obscene speech has shifted to organizations like schools and libraries, and ultimately parents at home. The American Library Association, of course, opposes blocking software. And the other question that has been raised is whether children have constitutional rights. The idea that a child also has the right to free speech is still trying to be answered. Now, when we think about all of these various laws, they all seem to focus on children and the rights of adults to have access, whereas children should not have access. And again, the government had to step in to try and reflect this, and it took a few tries before they found something that actually they felt worked. I will tell you that having worked in schools for a long time, students can always figure out a way to get around the blocking software. One of the ironies is, of course, that most teenagers have a better grasp of computer technology than their parents or grandparents, and can oftentimes disengage the blocking software or get around the blocking software. So let's talk about blocking software. It is code, therefore it has become a substitute for law in regulating the internet today. It's usually set up to look for keywords to block sites. They have these things called bots, which search these sites, so it's rare that real humans are there to examine the sites, which is why legitimate sites about breast cancer or sites that discuss sexually transmitted diseases are often blocked, because even though they may be a medical site, they're only looking for certain words like breast and penis and vagina and all those very sexy words we like to use to describe our body parts. Now, the problem with blocking software is that the lack of precision can lead to over or under blocking of sites. So, for example, if you wanted to do a paper on the effects of heroin on society, you may not be able to because you're Googling heroin, which oftentimes gets blocked even in a preventative or medical way, because again, it's a tank trying to kill a mosquito. Some blocking software has a political bent, and it's either extremely conservative, extremely liberal, it's not neutral, so it may block sites that discuss homosexuality, addiction, or AIDS. So the blocking software in and of itself can be very discriminatory. Blocking software can allow the government to block anything they deem unacceptable, such as critical reactions to government decisions, and this is often done in China and Saudi Arabia. In this country, any attempt to cover up information is seen as violating free speech, and yet we were horrified when secrets are revealed and we find out that the NSA has the ability to scoop up all of our cell phone information, or that they've built in back doors to a lot of websites so they can go in and snoop around. So again, we as a society, Americans, have to decide what's acceptable and what's not acceptable. The problem is most of us don't pay any attention. So let's look at it from an ethical perspective. Ethicists believe that there are certain criteria that would support responsible control of the internet. The use of these controls should be voluntary. There should be political transparency in the controls. For example, companies that don't like birth control should not block sites that discuss birth control in a medical way. And controls should be low level. They should not be adopted by the government. So, from their perspective, it's really more of a crystal ball into how things are blocked and what gets blocked. So let's talk about some other censorship issues. Some companies, such as Apple, have made the decision to self-censor, so none of their apps for iPhones or iPads allow pornography. Which, again, if you're an adult and you want to look at naked bodies, that is considered your right through free speech. So Apple has pretty much made the decision for you. Now, a major issue with mobile devices is also the access of online violent video games. California tried to regulate access to these online games in 2005 by introducing a ban on the sale of certain violent video games to children without parental supervision. So in other words, NC-17 kind of thing for a particularly gruesome web game or video game. So that lends the question, do video games count as free speech? Brown versus the Entertainment Merchants Association was the case, and the United States Supreme Court struck down the California law. In a 7-2 decision, the court upheld the lower court decision and revoked the law, ruling that video games were protected speech under the First Amendment, as are other forms of media. So, no matter how violent the video game, it is also still protected under the First Amendment. According to the Supreme Court, video games fall into the same category as books, plays, and movies as entertainment that communicate ideas and even social messages, deserving of First Amendment free speech protection. Also, non-obscene speech cannot be suppressed solely to protect the young from ideas or images that a legislative body thinks unsuitable for them. So if something is not considered obscene in terms of there's no nudity and there's no sadomasochistic activity, then, blood and guts are fine for the young people. Another issue is hate speech, and the definition of hate speech is speech that attacks, insults, and demeans whole segments of the population, such as Jews, blacks, Arabs, gays, Italians, etc. And there are approximately 7,000 websites that promote hate speech, racism, and anti-Semitism. And it's probably many more than that if you type in to Google words in French or German, Italian. We're just looking at English-speaking websites. Some of these sites are created by Europeans but are hosted on American servers because Europe, especially France and Germany, have had anti-hate speech laws since World War II. And again, they live under the specter of Hitler and the Nazis and what they did not only to the Jews, but they also did terrible things to the Romanians, the Russians, the Poles. And so, this idea of hate speech in these two countries is seen as a very incendiary issue, and that they go out of their way to avoid this kind of speech. Hate speech is protected under the First Amendment of the United States Constitution, and this was reaffirmed by the Supreme Court in 2011 in the court case Snyder versus Westboro Baptist Church. The Westboro Baptist Church people are the folks who go and picket outside of military soldiers' funerals, saying that they're dead because the United States is too liberal and it allows Jews and it allows gays and all that stuff. So Snyder was a family whose son was killed in duty, and the Westboro Baptist people showed up to protest, and Snyder filed a complaint, and this went all the way to the Supreme Court, where the Supreme Court did in fact say that Westboro can in fact do this. And, consequently, they got a lot of free press, and their message of hate has been persistently and consistently affirmed by our government. The issue comes down to the fact that there is a fine line between hate speech and unpopular political opinion, and it's almost too fine to parse it out. Then we have something called anonymous speech. Software programs such as Tor enable people to hide their identity online, often to evade surveillance. Examples of when anonymity is important. So, for example, if you want to go online and you want to investigate a sensitive medical condition, such as impotence or depression or an STD, then you have whistleblowers, who are people who work for companies or the government, who basically come forward and say, listen, my company or this department in the government is doing things wrong. And as a consequence, they often face retaliation by their company or by the people they work with. And then another option here is political dissent. In this country, we're used to political dissent to a certain extent, but people get ripped apart online, and they are hounded and pursued and stalked. So a lot of people choose to go anonymous when they are disagreeing with a government policy, because they just don't want to face the real world implications. It can also be abused. For example, criminals and terrorists can communicate anonymously to plan their activities. It can allow people to communicate inappropriately, such as bullying. It can allow people to libel others, and it can be used to reveal trade secrets or violate copyright protection. We're going to go into a lot more of these conversations in later chapters, but anonymous speech has its benefits and its absolute negatives. Another issue that we're dealing with as the internet becomes more and more of an opportunity to express our opinion is the idea, are bloggers journalists? One of the big issues in the past 10 years is the proliferation of bloggers. If I want to get online and have a blog, I can do it. Anybody can do it. And I can write whatever I want, whether it's an informed opinion or complete hogwash. Many of the bloggers who write about the news claim they are journalists with the same rights to protect their sources. However, so far the courts have disagreed. Some bloggers vow to practice ethical blogging, which involves telling the truth always, checking their sources, and identify those sources whenever possible so the readers are fully informed. Retract information that is proven false, and disclose any conflicts of interest in cases where their objectivity may be questioned. So if I'm secretly being paid by a company to talk about the fabulousness of their product, I need to disclose that. But the fact of the matter is, most bloggers do not feel any need to follow the ethical standards that journalists are trained to follow. Then we have spam, and we're not talking about the delicious canned meat product. Spam in the online world is junk mail that is sent electronically. It costs much less than regular junk mail to send, because all it takes is time and an internet connection. The real cost, however, lies in how much time a person who receives the spam devotes to deleting it, and how much space it can take up on a server of an internet service provider or an email provider. And what that means is that the person who sends it out, they can send it out to 10 million people, and that spam sits on those people's email servers until it's deleted. Now, in 2004, the Can-Spam Act was passed, and this act regulates commercial email. It requires that there is an opt-out mechanism. It has to be available. Identification of the email as an advertisement, and you will often see up at the top of an email, this is an advertisement. A valid return email and physical address of the sender is available. So you may hit reply and it goes into a junk universe, but there's usually somewhere in that spam that has the actual information of who is sending this information out. But it's probably in, 2-point font and barely visible. So the big question is, does it actually work? And sadly, no. The act has proven ineffective since spam emails have increased since this act was put in place. And there are filters provided by mail servers which control a lot of the spam emails, but now spam is popping up on social media. So, when you go on Pinterest or you go on Facebook, there's all of this junk essentially showing up in your wall that wants you to purchase things, which is really the whole point of spam. So that's going to finish this chapter. And if you have any questions, please email or text message me, and I hope you have a great day. Thank you.